I'm going to talk about Brexit and the implications that it has for deals that are being negotiated now, for antitrust enforcement, and why it's important. I don't want to dwell on the current status of Brexit beyond describing the overall context and the political developments that can be foreseen going forward. So where are we at the moment? Well, the UK is due to leave the European Union at the end of March, 29th of March 2019. The government has spent the last 2 years negotiating a withdrawal agreement with the EU, which was essentially intended to preserve the status quo, at least until the end of 2020. It was described as a withdrawal agreement or a transitional arrangement, and it was intended to dull the impact of Brexit and give the government and the European Union more time to prepare for Brexit proper. The trouble is that it was controversial, it was hard negotiated, and ultimately rejected by the UK Parliament just yesterday, so on the 15th of January. So now what? The rejection of the withdrawal agreement doesn't mean that Brexit won't happen. It simply means that unless in some way some major intervention takes place, it means the UK will still leave at the end of March 2019 in about 70 days, but without a withdrawal agreement, without the transitional arrangements, and without the preservation of the status quo. And which is why people refer to Brexit in these circumstances as a hard Brexit or a cliff edge Brexit, where the UK falls off and severs its relationship with the European Union with nothing to ensure that trade and regulation continues to exist and govern the relationship between the UK and the EU. So I said, unless something happens in between, some major intervention, what sort of interventions could there be? It is possible, legally possible, provided that the UK government asks, to extend the period for negotiation beyond the end of March. But the UK needs to ask, and the European Union and all of the member states need to agree to such an extension. The official opposition, the Labour Party, is trying to push as its primary objective for a general election, but it seems unlikely to achieve that. Today, the 16th, the government survived a no-confidence motion put forward by the Labour opposition, which means that the government is pretty secure and there won't be a general election, at least not in the very short term. Another possibility is a second referendum, but the government is bitterly opposed to that as well. And without a referendum, it seems to me impossible to revoke Brexit altogether. So the only prediction that one can make with some degree of confidence is that the government will ask for an extension to try to negotiate a deal that better wins the support of Parliament. Whether that's achievable or not is anybody's guess. So, turning now more to the implications of Brexit and why is this important for the European Union and the UK, it's really because European Union law has made its way into practically every aspect of the UK economy and relations with the European Union and social life. So the labour market in the UK, agriculture, the health service, the education service is very heavily dependent on migrants from the European Union as well as from beyond. All trade flows with the European Union are governed by the European Union single market. The EU is the UK's biggest trading partner. So many aspects of economic activity, the financial services based in London, which is, I believe, the biggest in the world, is regulated by European Union law. The energy market, if you think of electricity interconnectors and gas pipelines, are part of the European Union single market in energy and covered by European Union law. Patent enforcement as well. Pharma sector, aviation, the ability of planes to fly between the European Union and the UK is all governed by European law. But it's also trade between the UK and the rest of the world. The UK, as a member of the EU, benefits from all of the trade agreements that the EU has negotiated with many countries around the world. It will be excluded from those when it leaves. So it's difficult to think of any aspect of life which is in not some way affected by the UK's membership of the EU and which will not be affected by the UK's departure. Turning to antitrust enforcement, the big change is that at present the UK is covered by the EU jurisdiction. After Brexit, it will not be. So that means that cartel investigations, complaints, abuse of dominance investigations, which the Commission carries out and which include the UK, will no longer include the UK. So if you consider an international cartel case, goods which are sold into the UK or goods which are imported into the EU into UK ports, or abuse of dominance investigations, the cases that the Commission has been bringing against companies like Google, and which include the UK as part of the EU, the European Commission will have no jurisdiction to pursue those cases insofar as they relate to the UK. The UK's Competition Authority has said that it intends to pursue those cases on its own. This will have a significant impact on the work of competition lawyers, particularly those based in the UK. And the same is true for merger control as well. The UK authority expects there to be a doubling in the number of merger filings that it has to handle. It's been investing in increasing its resources to handle this increase, but it's been doing so on the assumption that the transitional arrangements until the end of 2020 would be in place. It is clearly not sufficiently resourced to handle a very significant increase in work if the UK leaves at the end of March of this year without any transitional arrangement. And thirdly, state subsidies. State aid law is a very significant aspect of European competition law and occupies a very large part of the European Commission's activities. But it's entirely a creature of European Union law. There is no national state aid law. The UK has committed to recreating its own state aid law following Brexit. It has been setting up a team to handle this. This is relevant in many sectors, energy included. A lot of the tax regimes that have been introduced in order to stimulate or incentivize investment in green energy, wind farms for example, have been reviewed as state aid issues. So the UK will have to establish its own rules to deal with those sorts of tax incentives and other stimulation measures. Final area I'd like to cover is the impact of Brexit on deals, and particularly deals which are under negotiation now or over the next few months. The impact is particularly acute in relation to the conditions precedent that are invariably included in acquisition documents, identifying the merger control jurisdictions where clearance is required before completion can take place. At present, it would be common in relation to a deal that requires EU merger clearance for the EU to be identified, or the EU clearance to be identified as a condition precedent to completion. So what would be the impact of Brexit? Well, if there is a withdrawal agreement in the similar in shape to the agreement that was rejected by Parliament yesterday, and if it achieves the same sort of thing, then the status quo would apply and European Union merger clearance would be available, including for deals which would otherwise fall within the jurisdiction of the UK. But if there is no withdrawal agreement, then the position is much more murky and much more uncertain. So if it is possible in the context of a deal which is under negotiation now to identify that the parties satisfy the jurisdiction of the EU merger control regime, and if clearance is likely to be obtained before Brexit date, then one would proceed as normal and obtain European Union merger clearance. But if there is any uncertainty as to the timing, if the jurisdiction hasn't crystallised and it's not clear that clearance would be obtained before Brexit date, then it would be necessary to assess whether a parallel UK clearance should also be sought, in addition to EU clearance. And in this regard, it should also be noted that the UK Competition Authority has the ability to review mergers until 40 days after they have closed. So it's conceivable that EU merger clearance might be obtained, but the UK Competition Authority may effectively retroactively seek to investigate and potentially raise its own concerns and seek its own remedies in relation to the transaction. It's also to assess what would be the impact of Brexit and the exclusion of UK revenue when assessing whether the EU merger control thresholds are satisfied. Those thresholds are based on revenue. Post-Brexit, it would not be possible to include UK-derived revenue when determining whether the EU merger control regulation applies. So if one is looking at a deal now, but where the assessment of jurisdiction needs to be made after Brexit occurs, it would be necessary to determine whether the EU thresholds are still satisfied when the UK turnover has been excluded. And if the EU jurisdiction thresholds are not met, then it would be necessary to assess whether national filings should be made. All of that is crystal ball gazing because one doesn't know, standing here as I am today, what the position is going to be on the 29th of March 2019 between now and then and beyond. That is a level of political uncertainty which is very hard to assess. The difficulty is when one is drafting a contract for the sale of a business or a company. And in my view, it's necessary to try to address that uncertainty in the drafting of a condition precedent, which would lay out the various different possibilities and the impact of these jurisdictional possibilities in the way that the deal is assessed, depending on jurisdiction and timing. So it would be necessary to draft a condition precedent which addresses the various different jurisdictional outcomes and possibilities, and to do that now in a way which reflects the various possible outcomes to the political evolutions that we will see over the coming weeks and months.